Welcome back to Law Stash Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. Last year, I made a video series dealing with vehicular searches conducted by police. And it seems like a lot of you guys enjoyed those videos and you liked the fact that I gave an overview and then we went into detail about each scenario. We're going to do a similar thing here. I decided to make a new series dealing with conspiracies. It seems like a lot of my clients and people often email me about being charged with a conspiracy. There's plenty of statutes that cover conspiracies. There's a federal statute that prohibits conspiracy in general. And then of course there's tons of statutes that are specific to a crime. Now in this series, what I'm gonna do is first we're gonna discuss conspiracy in general. I'm gonna give you a roadmap where we're headed. And then in the next 10 or so videos, we're gonna go in detail discussing each case as it pertains to an element of a conspiracy. So hopefully you enjoy this new series. Welcome to the first video in a multi-part series dealing with conspiracy law. I will begin by saying that federal prosecutors love charging individuals with conspiracies. Why? Well, there's a number of reasons, but I think the biggest is that it creates a bigger case. More defendants, more crimes equals a bigger case. And usually those bigger cases are more difficult to defend. And another reason is that when you have multiple defendants, you create a race between them to rush into the United States Attorney's Office and to cooperate against each other, thus making the charge easier for the prosecutor to go forward in trial. So let's go ahead and look at the overview of conspiracies, and then in the next number of videos, I'm going to discuss each case pertaining to an element of a conspiracy in more detail. So here's what we have to start with. 18 U.S.C. 371 is a general conspiracy charge. It is a conspiracy to commit any other federal crime. But we know that there's plenty of other federal statutes that deal with conspiracies. For example, 21 U.S.C. 841 and 846 are more specific charges. Those are conspiracies to distribute narcotics. We often see those charges being brought against individuals with narcotics. And for example, money laundering, a conspiracy to commit money laundering, has its own statute. So prosecutors don't have to rely on this 371. Something to remember, conspiracy is a separate offense, meaning that conspiracy to distribute narcotics can be charged separately, and it often is charged separately from the crime itself, the distribution of narcotics. It creates, again, a bigger case, but it is separate. You do not have to be charged with the distribution of narcotics in order to be charged with a conspiracy, and vice versa. Those are separate charges. The next item that we have to discuss is Pinkerton liability. Now, this is a case that I'm going to later discuss with you in more detail, but here's what it stands for. A conspirator's actions may be attributed to all members of the conspiracy, subjecting them to criminal liability for substantive crimes of co-conspirators. What does that mean? Here's an example. If individual A commits one crime, and then individual B commits crime 2 and 3, well, guess what? If they're in the same conspiracy, and if these crimes are done in furtherance of that conspiracy, person 1 would be responsible not only for that first crime that he committed, but also his co-conspirators' crimes. So he now has 3 separate crimes. Same with a co-conspirator. That second person will also be responsible for the substantive crimes of the first person. So we have more crimes. A lot of times people discuss Pinkerton liability as hub and spoke idea, meaning that there's somebody in the middle, there's other individuals that work to help the conspiracy, and some of them might not even know each other. But if they work to help the conspiracy, to promote it, they can be responsible for each other's crimes. Next, we're going to discuss the elements of a conspiracy. There's 3 elements to a conspiracy, and I'm going to discuss and look at the cases again in more specificity later on in this series. But here's the idea. Conspiracy is an agreement between 2 or more persons to commit an unlawful act. Guess what? If you and your buddy are deciding to join together for lunch, that's not a conspiracy. There's nothing unlawful about having lunch together. But if you and your friend decide to rob a bank together, that's a conspiracy to commit robbery or burglary. Now, to define further an agreement between 2 individuals for an unlawful act, here's something to remember. The prosecutor does not have to identify all co-conspirators. In fact, you can be charged with a conspiracy alone. He doesn't have to tell you who the other individuals are in a conspiracy. Acquittal of one of co-conspirators is not a defense, meaning if both of you go to trial on the same charge and one of you is acquitted, it doesn't mean that this defendant can now use that as a defense. And finally, in order to prove disagreement, it doesn't have to be a direct evidence. It doesn't have to be a phone call between 2 individuals saying, yeah, let's do it. It could be through circumstantial evidence, meaning that we don't know if you really talk to each other, but we have evidence that one of you purchased an item in furtherance of the crime, the other individual put it together, so we have some sort of agreement. We can look through circumstantial evidence to prove a conspiracy. The second element is that there's knowledge of the agreement and voluntary participation on behalf of co-conspirators, meaning that you have to be knowingly joining this conspiracy. But it doesn't mean that you have full knowledge of the conspiracy. A lot of times my clients don't know other individuals in the conspiracy on the indictment because they've never met them. But somehow these individuals ended up being on the same indictment. As long as you know the purpose of the conspiracy, the prosecutor can join these individuals together. So you don't have to have full knowledge of the conspiracy, but as long as you know the general purpose. And something to look out for is prosecutors sometimes try to bring in a willful blindness idea into trial. Sometimes they bring it in terms of a jury instruction, meaning that somebody avoided knowing, meaning that the way they agreed or joined the agreement, the way we can see knowledge is by them avoiding knowing about the conspiracy. Something to look out for. And finally, depending on the statute, some statutes require it and some don't. The statutes that do require this third element, the element is that one of the conspirators has to do an overt act. What does that mean? It's an act in furtherance to accomplish conspiracy purpose, the purpose of the conspiracy. Meaning that it's a step forward in the direction of completing the crime. It does not need to be an illegal act. Think about it. In furtherance of a conspiracy, it could be something like placing a phone call, or traveling to another city, or going to purchase a firearm legally. It's any act in furtherance of that conspiracy. Then later on in the series, we're going to deal with joinder. Under Rule 8 of criminal procedure, prosecutors can join common charges and defendants together, creating a bigger case. But something to look out for is, do we have one conspiracy, one big one, or do we have multiple conspiracies? And the prosecutor is really overcharging you because you're not part of this other conspiracy. It could be that a smaller one existed without the knowledge of this bigger conspiracy. So something to look out for is the number of charges and the number of the defendants, and whether this individual, the defendant or your client, is in fact part of a conspiracy. And finally, we're going to conclude this series looking at cases and defenses. Mere presence at the scene or association with co-conspirators does not equal intentional participation. So just because you're hanging out with these individuals who are in a conspiracy does not mean that you're part of it. It could be that you're simply there, but you have not joined the actual participation in a conspiracy. Withdrawal is a difficult defense to prove, meaning that you withdrew from the conspiracy. Why? Because usually the law requires that a person makes an affirmative act to defeat and disavow from the purpose of the conspiracy. A lot of times it means a full confession before the crime is committed, before you're charged. And so those are rare cases, but it does happen, and we're going to look at some of those cases. This defense, single versus multiple conspiracy, I just discussed this earlier, meaning looking at how many people are joined together in the same indictment. Evidence of a mere buyer-seller relationship is insufficient to show a conspiracy. This happens all the time. In a conspiracy to distribute narcotics, we often see a buyer purchasing narcotics from a seller for personal use. That is not enough to show a conspiracy. Now, if the buyer is purchasing narcotics to redistribute them further down the road, well, that's another story. That could in fact be a conspiracy. And finally, we're going to look at some of the cases dealing with statutes of limitations. Why is that important? Well, first of all, statute of limitation means a period of time when the prosecutor can bring the case in front of court. At some point, the charges can be too old, and at that point, the prosecutor is not allowed to do that anymore. Why is this important in terms of conspiracies? Well, because usually conspiracies are ongoing offenses. It is not like a crime of larceny where somebody comes in and steals something. No, this crime takes a period of time to complete. Often enough, individuals come together, come into agreement, and nothing happens for months. People plan things together. So the conspiracy moves forward. And as the conspiracy moves forward, in order to figure out the statute of limitations, the years during which the prosecutor can bring the case in federal court, we have to know the period when that statute of limitation begins to run, meaning when is the conspiracy over? Now you understand some of the defenses to the conspiracy. So here's what's going to happen next in a number of videos. First, we're going to discuss the conspiracy in general. Of course, one of the first cases is going to be Pinkerton Liability. Then we're going to discuss each one of these elements in more detail and look at the cases. And then we're going to see some of the defenses that other individuals brought in federal court. Hopefully you enjoyed this series, and if you do, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And finally, please share my channel with your friends. It really helps me out.